So that big story tonight, Chief Justice David Maraga, perhaps we should be calling him retired Chief Justice now, as I mentioned earlier, attaining the age of 70, which is the limit requiring him to vacate office, which he did. And there was a ceremony at the Supreme Court earlier today. He handed over the instruments of power to the Deputy Chief Justice, who's now set to act as Chief Justice. That's Philomena Mwilu. That's for the next 6 months as the Judicial Service Commission embarks on recruiting the nation's next CJ. So for the next half hour or so with my guest this evening, I want us to look into the scorecard. How did Maraga perform whilst in office? So once again, Honorable Karua, thank you so much for being with us tonight, and Professor Ojienda for making the time this evening. I'll begin with you, Professor Ojienda. You are in the panel that recruited CJ, now retired Maraga. And in the end, as you tell us on a scale perhaps of 1 to 10 what you make of his performance, the person you recruited then, and looking back in hindsight at his term, disappointed, or has he sufficed to be the candidate that was right for the job at the time?
I think, Sophia, that the Chief Justice performed just well. He upheld the Constitution of Kenya, and he was able to demonstrate the qualities for which he was appointed as set out under Sections 5, 1 and 2 of the JS Act. And above all, I think that the rule of law is supreme. He upheld the rule of law. Chief Justice Maraga came in on a foundation of implementing what we had then called the Judicial Transformation Framework, and he came up with SFT, which is Sustaining Judicial Transformation. He has done well. He has taken IT to the next level. He has taken virtual hearings to the next level. Chief Justice Maraga has shown us that even in the period of during adversity, even when it is not going so well with the executive, you can perform as a Chief Justice. He has served his term. He has left. He has retired. He has done well.
Honorable Karua, I'll come to you. His term has also been very controversial. We have seen the kind of fallout and issues with the executive especially. And so we're actually going to break down his roles into 3 and begin with, because he was not only the head of judiciary, which is an arm of government, he was chair of the JSC, which is the umbrella body for the judiciary, but also the president of the Supreme Court. So beginning with the head of the judiciary, requiring to be engaged with other arms of government, those kind of linkages, and what we witnessed. How do you rank his tenure?
I think he did what was expected of him administratively. When you look at the 3 arms of government, the president is the first among equals. He's the one who can give appointments, not the CJ. And the CJ said that he sought appointments with the president when he needed them. But when there was friction, he never got access. So he did what was expected of him. But commenting on what Professor Ojienda has just said, I will say he did well on some things, and the court, his court, the Supreme Court, did not do all that well. I would give them 50-50. 2 very momentous rulings behind him. 1, the nullification of the presidential election 2017. That was rare courage and upholding the rule of law. The second one I credit him with is his advisory to dissolve Parliament for disobeying the Constitution. He followed the courage of his conviction. But under him, the Supreme Court as a whole must take responsibility for inconsistencies, glaring inconsistencies in jurisprudence. Therefore, he did well in some things, not in others. Yes.
All right, and back to you, Prof, on that. Perhaps I'll pursue first the head of the judiciary and what we witnessed with the executive. And as Honorable Karua has mentioned, the revisit comment that came off of the nullification of the presidential election. Do you think that he had any part to play in that fallout? Does he share the blame, or was it this entirely according, and in your view, the executive interfering, and that he did what could have been done by anyone in his situation?
Sophia, one of the pillars that informed the hiring of Chief Justice Maraga was the ability to network. And of course, given he had a multiplicity of soft skills, when you interview a Chief Justice, you want to get that person who can deal with the other arms of government. And looking back, I think that whatever Chief Justice Maraga retired did was out of the impossibility to engage. I will tell you this. Chief Justice Maraga, of course, is a religious man. And I know that he reached out. I'm also aware that as head of judiciary, he would always consult on difficult decisions. The judiciary budget moved, for instance, from 17 billion in the financial year 2017 to about 13 billion the following year after the nullification of the elections. So you could see a continued deficit that he had to deal with. He could not be able to sustain the construction of the courts pursuant to his task to ensure that Article 48 of the Constitution, access to justice, is met, one of the key pillars in SJT. And you could see frustration in him. I think severally he must have sought to see His Excellency the President. It was not easy. And I believe, therefore, that he did the best that he could within his ability as a Chief Justice. And therefore, I'm often slow to fault him on certain things over which he had no control. But maybe a few flip-flops here and there. I think because he did not speak out so often over some of the things until I think at some point he held a press conference, people would not have known what was going on. And as a Chief Justice, I think he kept his cool and could not share every time with the public the difficulties that went with all these processes. But I think that the failure to appoint the 41 judges stood out. He spoke about the budgetary deficits, that was clear. But when the 41 judges were not appointed, there were court cases and various court orders, and the Chief Justice spoke to those questions. Those judges, of course, remain unappointed, or they haven't been sworn into date. I think really he had no control over some of these questions. And I do not want to blame him for the failing chemistry between himself and the executive. It would be difficult to ascribe blame on the retired Chief Justice. Perhaps these political legal questions are difficult to deal with because, you know, that is fairly, you cannot comment or you cannot put blame on questions of relations and the ability to nurture relations. But I think going forward, when you looking for the search for the new Chief Justice, I'm sure it would be important to ensure that we have a candidate or a Chief Justice who would be able to manage the delicate relationship with the executive and Parliament at the same time.
I hear you, although then that would become an indictment. On one hand, you say he was helpless, he did best he could, but that the country needs a CJ who can handle those relations. So what if they find themselves in a similar situation as you make a case for him? But allow me to take this to Honorable Karua, because There are those who opined that the CJ before Maraga Mutunga was in some quarters viewed as an activist. But yet we never saw his engagement with the executive degenerate to levels that we have seen in this past tenure, with the calling out of each other in press conferences, both from the president and the Chief Justice himself. So for you, what's the disconnect there, that perhaps that was a totally different tenure that we saw with Mutunga, and now this with Justice Maraga?
You remember that the president loudly expressed his distaste with the Supreme Court when they nullified his election. He promised to reverse it. So when the Chief Justice, the outgoing Chief Justice, sought audience on critical issues and was not given audience, Kenyans and the CJ himself interpreted this as a revisit. When their budget was slashed, these were the outstanding issues. So you really cannot compare the tension during the tenure of the first Chief Justice under the 2010 Constitution, Dr. Willie Mutunga, and the tenure of Chief Justice outgoing Maraga, because there were different circumstances. I will repeat, failure to give audience cannot be blamed on Chief Justice Maraga. He expressed himself and he said he sought audience. We didn't hear the office of the president deny that audience was sought. The responsibility or the failure to have that audience where they could one-on-one sort out those issues must be blamed on the executive, because it is the executive, the president, basically, who ought to have given that audience. The Chief Justice cannot storm State House or Harambee House. And I've said the president, being the first among equals, bears the greater responsibility to reach out when there is a standoff. Again, looking at it broadly, tension between arms of government is healthy, but when it degenerates to stonewalling, then it becomes unhealthy. Like, we cannot have a situation where there is a recommendation from the Judicial Service Commission for appointment of 41 judges, which drags on to the second year. There must be a solution, especially remembering that the Attorney General, who is the appointee of the President, was present during the appointment of these judges.
Right. And I'll follow that up perhaps with a brief comment from you still, Honorable Karua, because the grandstanding or this kind of sibling rivalry, as they're called sometimes, with the arms of government, have been witnessed, for instance, in Parliament, the National Assembly and the Senate. So for the judiciary going forward, especially in regard to their relationship with the executive, is there something that can be done to ensure it does not degenerate to the levels we saw it do in the last 4 years, or at least 2 years?
The heads of the three arms of government must at all times exercise the functions of their office with utmost reasonableness and responsibility, knowing that these are not, the powers they have are not personal, they belong to the state. So even though you do not like or you are not happy with a person, you must avail yourself to execute the functions.
But when that doesn't happen, like it didn't happen in this case, when it doesn't happen,
then it is a most unfortunate thing. In a proper case, Parliament can censor, but if Parliament is party to that, because you remember the Parliament also threatening the judiciary, at the same time the executive was threatening it. So the behavior of the three leadership of the three arms of government has not been up to date, and especially Parliament and the executive. You have seen that even when the judiciary is unhappy, the executive and everybody else are taking their cases to the judiciary, and they are given the priority they deserve. They are heard. So I do not see any reason to fault the holder of the office of Chief Justice, and to suggest that we shall be looking for qualities of a person who can be able to lower the tension between these institutions is to suggest that we should have a person who is subservient to the executive, for instance, or to the executive and parliament.
Yeah.
And that is contrary to the principle of independence of the judiciary.
Professor Ojienda, you perhaps had Honorable Karua earlier talking about what she felt or how she felt and thought the outgoing, now retired Chief Justice performed regarding his role as President of the Supreme Court. And she touched and mentioned jurisprudence and expanding that room in as far as the space Kenya operates in the rule of law. Do you share the same sentiment?
The Supreme Court under Chief Justice Maraga made a few landmark decisions. I think that, of course, the most outstanding is the nullification of the presidential election in 2017. That is outstanding because it was a first in Africa. Then you have other questions on jurisdiction, including cases like the Mwilu case, the Geochem case. Those are other cases. I know that Honorable Martha Karua must be addressing herself to one case that involved her, and where the East African Court of Justice made a pronouncement that ran counter to a decision of the Supreme Court. I think those are some of the flip-flops that she's talking about. But I think wholly the Supreme Court, as we have today, is solid. They make certain interesting decisions. Today they made an interesting decision on socio-economic rights, the Mwilu decision, which followed closely on the jurisprudence of South Africa in the Grootboom case. So largely they are doing a good job, but they can make it better. Remember, we are missing one judge of the Supreme Court. The former judge of the Supreme Court, Justice Ojwang, retired as well, and he also had his mark on the court. I think that must be remembered, that we are not just looking for a Chief Justice, who is, of course, the jurisprudential head of the court, but we're also looking to replacing Justice Ojwang, Professor Ojwang, who was a very solid judge. Judge Maraga has done his best on some of those questions. Remember, Article 159 and 160 of the Constitution call, and I agree with the Honorable Martha Karua, called to the independence of the institution. That is, the institutional independence of the judiciary and the decisional independence of judges, which must be preserved by the Chief Justice, so that if you have a Chief Justice who then does not stand firm in defense of the institution, then the entire institution will crumble. So as we look for the next Chief Justice, of course, it is clear that we'll be looking for a person who will uphold judicial independence and who will stand fiercely in defense of the independence of judges, one who is also sharp enough to be the jurisprudential head of the institution, but also one who will lower the temperatures. I believe it is possible to get all these 4 qualities or 5 qualities in one person. And I think it also serves the interest of this country that we are able to get an individual who can nurture the working relationship between the executive, parliament, and the judiciary.
All right, so what I'm hearing
I think that is not too much to ask.
What I'm hearing largely from both of you tonight is praises and appreciation and perhaps admiration for the work that David Maraga, retired, has done over the last 4 years. So let's take the conversation forward to what you've touched on, the next Chief Justice, and begin at the point of the now acting Chief Justice, who's also the Deputy Chief Justice. And I'll start with, there's a matter in court. We'll wait to hear how that will be determined. But how do you understand, for those who have argued there is no room in the Constitution, or it doesn't envision or speak of an acting Chief Justice as we have now, Honorable Karua?
Before I answer that, I really must answer my colleague, Professor Ojienda, that when I say that there has been lack of consistency of jurisprudence, I'm not referring to my case per se. I'm referring to the jurisprudence on election petitions. If you look at the Wajir case, if you look at several cases, you are not able to discern what the Supreme Court makes of Article 86 and adherence to it. So without going into discussion, I just want to refute the notion that I would assess him based on my case. It's based on general jurisprudence. Having said that,
in the Wajir case.
Having said that, on the question of what qualities we are looking for or who are the applicants, I think we have to let the cases that are in court go on, but also let the public know that the Judicial Service Commission is required to put in place a selection panel which will help select the new Chief Justice. And the applicants must come from among the eligible persons. At this stage, I would hesitate to comment on the eligibility of any of the supposed applicants whom we do not know, because when it is advertised, it is when we will know who is applying. As to whether the Deputy Chief Justice can act, a deputy is supposed to act in the absence of the substantive office holder. As of today midnight, outgoing Chief Justice Maraga retires. So the Deputy Chief Justice assumes office. Whatever matters are pending with regard to her, remember she is not under suspension. So she automatically moves into act. This is something that was foreseeable. The Judicial Service Commission knew when the Chief Justice was due to retire. It's not something that has just happened. Any deputy assumes office in the absence of the substantive office holder, including in retirement.
But Honorable Karua,
that's the legal position.
The JSC, at least it had been reported at some point, had wanted to commence that recruitment process so that in essence a substantive CJ would be found in good time, even before Justice Maraga left. However, it was then something that we saw end with a decision that it would not go that way. He maintained he was the Chief Justice up to today, which he has managed to do and stay in office until then. But wouldn't it have been wiser to begin the process earlier, like we saw the other CJ Mutunga exit early, to allow for that replacement? What are your thoughts on that?
That depends on the person. Chief Justice Mutunga did it out of his own volition, not because the law says so. Chief Justice Maraga decided to serve his full term. You cannot fault him legally.
But to begin a process,
at a different stage,
to begin a
the
process,
law is amended.
Right.
If the law is amended, he could have if he wished. He did not wish.
Okay.
So tomorrow, if we want to amend the law to make sure that the recruitment happens earlier, we can do so.
Okay.
But he has legally served his term.
Right. Prof. Ojienda, perhaps your thoughts on the same, whether that process should have begun whilst Maraga was still serving, continuing with his duties, because it's a process. There's a clear outline of how it works. So should it, in your view, have begun earlier? And as you speak to that, there are concerns in some quarters that on one hand you see cases of, say, governors who have issues, whether it's corruption allegations. There have been court rulings that those governors do not step into their offices and they stay away. You have ministers who have stepped aside, again, facing issues around Chapter 6 and integrity. So you have this Deputy Chief Justice, who's now going to be acting as CJ, facing several petitions on her suitability to hold office. So shouldn't the same apply to her, that she either steps aside until this issue is handled, or the kind of standards we've seen applied to other offices. So are there double standards is the question regarding how she's being treated and the issues she faces?
Sophia, 2 points. One, the recruitment of a Chief Justice cannot commence when there's a Chief Justice in situ. There must be a declaration of vacancy. Upon Honorable Chief Justice retired Maraga's exit tonight, there shall be a declaration of vacancy, and that notice of vacancy is supposed to last 14 days. Now, the notice of vacancy will be shared with many institutions so that applicants then prepare to apply, because notice of vacancy will then be followed by an advertisement for the position of the replacement of Judge Maraga. So it could not have been legally possible to start the recruitment before he retired. In fact, when we recruited Justice Maraga, Chief Justice Mutunga had retired. Professor Kobia, now Minister for Public Service, chaired the process of the recruitment of Chief Justice Maraga. Then we sat as commissioners. We waited for Judge Mutunga, retired Chief Justice, to exit first. That is the position. Now, as I will share later, this process could take anything between 5 months to 6 months. If you look at the calendar time, the schedule, it takes a total of 166 days to hire a Chief Justice, considering the times that the public will give feedback, the shortlisting, the interviews, and depending again on how many people apply. Now, on Justice, the DCJ, Justice Philomena Mwilu taking over, under Article 166, read together with 167, upon the retirement of a Chief Justice, you cannot have something called an interregnum. An interregnum cannot be entertained in the judiciary. The Deputy Chief Justice performs roles assigned to her by the Chief Justice, and that is exactly what the CJ did today. He handed over the performance of the role of his office, role of the office of CJ, to Deputy Chief Justice Honorable Philomena Mwilu. She is the acting Chief Justice.
All right.
And it is, I do not know where those who say that she cannot act are getting their reasoning. That it's hogwash that merely because there's a petition against an individual in court that they cannot act as Chief Justice.
But you have governors being told not to step into their offices. And it's true, innocent until proven guilty. But why do those courts then be seen to be favoring their own? It could be argued.
The petition in question are for removal. They are not for conviction. There's no criminal case.
When the case was brought before court, the argument was that there was a shielding by the judges who sat to hear it by moving it to the JSC. And
it was quashed. That proceeding was quashed, and therefore there's no finding. But moving forward on governors, the question as to whether governors and independent office holders should leave office upon a charge being proffered against them is a live matter before the Supreme Court. In fact, it is one of the matters that we are still dealing with in the Supreme Court. There's been a judgment on the question in the High Court and in the Court of Appeals. I think that question is still live, but I get the point that you're making, but it does not apply in this case, Sophia.
All right, Professor Ojienda, thank you very much. Honorable Karua, as you make your closing remarks, please also address and speak to the same question, please.
Yeah, my view is this. Yes, on the face of it, it's a case of double standards. The judiciary in this case did not move fast enough to conclude the cases before it. The Judicial Service Commission did not act or find a way of ensuring that any matter before it concerning a judge that judge should not be allocated duties. We are not focusing on an individual. And this is where the holders of the office of Judicial Service Commission collectively and the office of the Attorney General did not move the court to ensure this happened. So that is water under the bridge. But tomorrow we must consider a consistent application of Chapter 6. It's not something we can ignore.
Yeah, perhaps add for me this, because you said it's not about an individual, but what still is concerning, and somebody is here, Peter Kiama is saying, we must also remember she is ombudsman listening to matters of concerning other judicial officers on discipline. So how is it that then this is now the head of the judiciary, albeit in acting capacity, but also ombudsman, and yet these other matters? So there is a concern there by this viewer that still the double standard, if you like, is glaring.
All those matters, even though she is the ombudsman, they later go before the Judicial Service Commission. So it's not as though she's solely determining matters on her own. That must be made clear. And yes, I've already said, these are issues to address, that the interpretation and application of the Constitution must be consistent and must be applicable to every person. And I've said the failure of the Judicial Service Commission and of the court generally to expedite matters that must be expedited. Because a judge, of whatever stature, against whom allegations have been made, it needs to be cleared as soon as possible.
All right.
So that if it's frivolous, it's dismissed.
Okay.
If it is valid, the matter is settled. You can't have such matters pending for years on end.
All right, in 10 seconds, Honorable Karua, there is Ojienda Omanda saying, I think Martha Karua would make a great Chief Justice. I wish she could get in the race. 10 seconds, would you consider it?
Thank you. I have chosen politics.
All right, asante sana. And to you, Prof, finally, several candidates have been put out. I'm sure you've heard them. You're in the legal profession. Who do you think would make a great replacement for Maraga? Briefly, 10 seconds, please. Our time is up.
I think so, Sophia, any of the applicants that are touted, all the names that have been touted are all good names. And the interview process will determine the best judge, whether man or woman,
all right,
to lead the judiciary. I think that in equal measure, all of them are good.
So we will wait then for the process to play out, and here on KTN News, we'll keep our viewers updated with that process. Honorable Martha Karua, Kenya Party leader, senior counsel, as well as Professor Tom Ojienda, also a senior counsel and a former commissioner in the Judicial Service Commission, with us tonight. Thank you so very much for making time for KTN Prime. And on behalf of everyone that made the show possible and you for watching, thank you. Have a good night. I'm Sophia Wanuna, our sign language interpreter tonight, Damian Evans. We are paving way now for Robinson Okenya, who's coming up with FKF Premier League. So lots of sporting action. Stay tuned. God bless.